Hi everyone, this is Adam Botterill from Tempest, and I've got here Damien Grant, my director, to my right. We've just watched the Decmil creditors meeting information session with Mr McVeigh, the liquidator, and his NZ lawyers as well, and lots of questions. Lots of questions.
Not many answers.
There were some answers there, but some big questions that we have are around that 750k of legal fees to date, and it seems like a pretty large sum looking at it from our perspective.
It's a staggering matter. So just to put it in perspective, for those of you who didn't watch it, so Mr McVeigh, not based in New Zealand, not able to hold a creditors meeting here, he did an information session, and one of the bits of information which he mentioned, actually mentioned it twice, is in the 2 months that he's been appointed, he's run up $750,000 worth of legal bills. He is spending $100,000 a month on lawyers, and that doesn't include his own liquidators fees. So far in 2 months, this guy's raked up probably over $1 million.
Yes, and the appointment happened in the middle of April, about April 15. So we've seen it's about 9 weeks he's been in office, and the question was asked by creditors in the question and answer session about what his liquidators fees were to date. Mr McVeigh said that his fees have not been charged, or he's charged no fees. What he hasn't told us is how much time he's recorded and what he's spent on the clock to date. So there's no visibility yet about what the total is in terms of fees on that insolvent company, but it'll be approaching $1 million. There's no doubt about that.
It'd be well over $1 million. And just to put it in perspective, I mean, he made reference to EBIT. The receivers of EBIT, I think, clocked up about $800,000 over like a couple of years, and some legal fees as well. So this, you have to hand it to the Australians. I mean, they certainly know how to charge. This $750,000 of legal fees is outrageous. It is a disgrace. There is absolutely no justification for a liquidator to run up those sorts of legal fees. He's either careless or he doesn't know what he's doing. And remember, there's only two actual things he's done. One, he went to court unsuccessfully to stop corrections claiming the bond, and he went to court for some nonsense reasons over the creditors meeting, which he didn't need to do. But here's the real standout. That $3.2 million. So when he took over the file, there were $3.2 million in the kitty. That $3.2 million had been paid by Decmil Australia into Decmil 2 weeks prior to liquidation. It is entirely possible, and in my view almost certain, that $3.2 million is retention funds. So I shouldn't say it's certain, but it's certainly one of the possibilities.
Well, also, Mr McVeigh said he's going to go to court to have the court decide where that money should be allocated, because he's not sure, as the liquidator right now, where he stands, whether it's retention money that's on trust for retention creditors, or whether it's general money that can be used for the general pool of unsecured creditors. He's not sure. He's told us in about 2 weeks' time or thereabouts, he's engaged a QC to go to court and have the court make that decision.
So let's just run this through. Adam, you're a lawyer, and you work in insolvency. Let's say that the 750, and it'll probably be 950 by the time we get there, of money that Mr McVeigh has spent on lawyers. If it turns out that the $3.2 million is, as I suspect, retention creditors' money, what's going to happen to the $750,000 that Mr McVeigh has spent on lawyers to date?
Well, it's hard to say exactly what will happen, but what I think should happen is that he'll have to pay it back to the actual creditors that are affected, because you'll have retention creditors there, and they'll see they've had a valid claim, 100 cents on the dollar ought to have been paid out if that money was applied to their claim, and then you've had legal fees and liquidators fees or other things taken chunks out of it. You would want to be made whole again, and the court's going to be very wary to allow a liquidator to use retention funds that should be separate and ring-fenced for general matters, such as the calling of the creditors meeting, such as for the injunction against corrections. You're going to have a lot of reluctance for those retention creditors to take a hit because Mr McVeigh's used those funds for other matters.
Yeah, it's just flat out outrageous. That $3.2 million was put in by Decmil Australia. So presumably Decmil Australia knew that they had a statutory obligation in New Zealand to hold retention money in funds. Immediately prior to liquidation, they made the New Zealand company whole so that they actually had the money there for retention.
Let's just back that up a little bit. They made them whole, but only for retention creditors.
Only for retention creditors.
Not for the unsecured creditors.
No, they can whistle Dixie as far as Decmil Australia is concerned. But under New Zealand law, the Australian directors were meant to hold the $3.2 million in funds. Now, let's take the Australian directors of Decmil, and let's assume that they're operating within the law. They, and Mr McVeigh talked about that they ran a one treasury operation, right? So if they ran one treasury operation, that $3.2 million was transferred by the Australians into the New Zealand entity immediately prior to liquidation, possibly with the expectation that under New Zealand law that $3.2 million would be used for retention creditors. Mr McVeigh has gone and grabbed at least $750,000 and spent it on lawyers. This guy just needs to go.
Well, it's also interesting. He's got lawyers in Australia acting for him as well. He mentioned he's got Clayton Utz and also Anthony Harper in New Zealand, and he's mentioned that his lawyers are representing him at the 261 interview or equivalent interview in Australia. You have to ask questions why Mr McVeigh, an experienced liquidator, would need to have external lawyers, Clayton Utz, representing and attending those interviews. It seems like that would compound the costs of the liquidation in a large way.
You're a liquidator. You have a 261 interview. You just hold the interview. You don't need a bevy of lawyers to do everything. And even in that information presentation, he kept referring back to his New Zealand lawyers, who presumably were charging for the hour
While we're on the topic still of that $750,000 in lawyers, a lot of the interactions that Tempest has had, and certainly myself, and dealing with Avior Consulting and Mr McVeigh, has been via Anthony Harper. So he instructed them to deal with.
Who are a good firm, to be fair.
Good firm.
We like Anthony
We've
Harper.
dealt with them before. They've, nothing against Anthony Harper, but the fact that the liquidator was using them to deal with creditor queries, it raises questions about the cost involved and who's bearing that, and it looks like here that the retention fund or potential retention fund will have to wear some of that cost. Yeah,
it's a concern. The other thing, he mentioned me a lot.
Did he? I didn't hear that.
Mr McVeigh?
Oh, right, you mean the 6 or 7 times?
Yeah. So obviously he's a big fan. Sorry, Dermot.
He might be watching this video potentially.
He's definitely
so
watching the videos. And to be fair, I've been in his position. I know what it's like to be on the receiving end of a challenge. But there are a couple of things here that I was particularly unhappy about. I've already stated that Tempest, we're a debt buying company. We are not dealing with corrections. Mr McVeigh made a number of, frankly, outrageous allegations. In New Zealand, it's a reasonably small pond, and so Buddle Finlay, I'm sure I have worked with BDO in the past. The allegation that Mr McVeigh seemed to be implying is that there was some sort of a jack-up between corrections and BDO. Well, I can confirm that is absolutely and unambiguously not the case. The only formal interaction that I've had with corrections is when I found out that they were a large creditor in this file. I went to them with my preferred liquidator. And my preferred liquidator was Ian Shepherd of BDO. That was not the initial preference of corrections. And I think that's really important to state. Corrections initially wanted somebody else. I won't mention who. But it was a compromise between Tempest and the Department of Corrections to get Ian Shepherd and Andrew Bethel of BDO. That was not Corrections' first choice. They acquiesced to my wishes in that. So that Corrections and us will at least be on the same page, because we were pursuing 2 different agendas.
And it seems what Mr McVeigh has tried to do through not only the meeting and information update, but also through the various flyers and circulars to creditors, is paint Tempest and Corrections operating in unison and in concert with the same goal and with the same mind, which is not the case. It's merely the case that Tempest and Corrections both would prefer a different liquidator to handle this job.
And look, if Corrections owe the liquidation $30 million, then all power to the new liquidators, because that's just going to result in more money for Tempest and the other creditors. And the inference seems to be that somehow, if BDO were appointed, they would somehow turn a blind eye to any claim against corrections, which is appalling.
Well, the inference is the same there for Mr McVeigh, because he was appointed by the shareholder, that he will then turn a blind eye to anything that the shareholders or directors of the parent company have done, and that's obviously not true. The liquidator will act independently and should act independently of who puts them in.
Yep. Scott Barker, who actually works for Butter Finlay, he asked a question during the session, and he asked two questions. One was what Australian liquidations had he been involved with, and Mr McVeigh kind of dodged that question a little bit. I think he mentioned one, Forge. But he also asked, Mr McVeigh said in that presentation that he'd worked on a couple of New Zealand files. Scott Barker asked him specifically what they were, and he wouldn't answer that question. Now, Adam, you actually went trolling through the Gazette for Mr McVeigh. What did you find?
I asked a similar question on the chat feature in the information session. I heard that Mr McVeigh had acted or had worked on NZ files, and I wanted to just get a clarification on what they were, because I'd done a search on the New Zealand Gazette, which is the public advertisement space for these types of ads when a liquidator is appointed, and I searched for Mr McVeigh, and the only one that I had found for his name was Decmil. So I hadn't found any prior insolvencies where Mr McVeigh had been the appointed receiver or manager or liquidator. So I was hoping that Mr McVeigh would answer that question and tell us what they were, because I failed to find that.
He did say he'd worked for Deloitte and was it Ferrier Hodgson. So it's possible he's worked on New Zealand-based files whilst working for those companies.
And perhaps not as a named liquidator.
Yes, he certainly hasn't been a named liquidator. So look, we've probably run a bit longer than what we intended to, but a couple of key takeaways from this. If you haven't given us a proxy yet, it's too late. You must submit a postal vote. If you're watching this and you're a creditor, you will have received a postal vote. Postal votes need to be in by Wednesday, so don't waste any time. Get in there, fill in the postal vote, vote no to Mr McVeigh remaining the liquidator, and vote yes to Ian Shepherd and Andrew Bethel of BDO being the replacement.
Well, I think it's just critical that we have a think about how we spend the resources and time, and $750,000 in 2 months on legal seems beyond the pale in terms of what we would have expected. So if you are concerned about the amount of cost and external legal cost especially, I think it's in your interest to vote no.